Good morning, my lords. I appear in this matter on behalf of, I think, properly speaking, the applicant, with my learned friend, Mr. Kirkhoff, and my learned friends, Mr. Simons and Ms. Foster, appear for the Forestry Commission.
Yes.
As your lordships will know, this is one of those cases that happen from time to time where you are the first instance judicial review court by order of Lord Justice Lewison,
That's right.
who granted us permission on appeal from the refusal on a renewal application by Mrs. Justice Thornton on the 3rd of November.
Yeah.
The papers, I don't need to take your lordship to those unless you wish me to go to them. But
No. I think it's clear. I mean, Lord Justice Lewison made very clear what he was doing, I think, in the order he made, and it was to grant permission to appeal. Yeah. Just before you go any further, two things. We are live streamed, I believe, so that these proceedings are received by a much wider audience than those assembled in court this morning. The second thing is simply to say this. For the life of me, I can't remember whether I have ever had in my professional life as a barrister involvement with Trago Mills. I really can't remember. I'm simply saying that because I want to get that out there. If anybody knows of anything, you ought to raise it now. But I simply don't remember.
Yes. Well, I dare say a number of us did from many years ago.
And I confess I haven't checked, but I mean, I simply don't remember.
And nothing turns, I think, on the specific location.
No.
It's the issue of principle that applies to it.
All right. And have you worked out broadly, we've got a day to deal with this if we need it, but have you worked out a broad programme of action?
Other than agreeing with Mr. Simons that ultimately the point is a short one.
Right. Well,
I hope that's encouraging.
That's an encouraging answer to my question.
Well, viewed comprehensively, my lord, the point is whether the planning exemption in section 9(4)(d) of the Forestry Act 1967 has enduring effect, so that Parliament's intention of exempting those planning permissions which are referred to in 9(4)(d), such that if the qualification to come within those planning permissions arises after the service of an enforcement notice under section 24 of the Forestry Act, the Forestry Commission is entitled to insist that you comply with the notice, even though it stultifies the operation of the Planning Commission for 10 years in this case. Or whether, as we submit, there is an implied power to withdraw the notice, which we say should be the case where section 9(4)(d) is engaged and the intention of Parliament comes into play.
Yeah. Fine. That's what one might call the substantive issue. There's also the question of timing or delay, whichever way one wants to put it. And you'll deal with that as well.
I will. I can deal with it first or last.
Probably doesn't matter as long as it's covered. It's touched on in your skeleton argument, but not fully developed.
Essentially, the point is this: this isn't a challenge to the enforcement notice, nor could it be, because the qualification under 9(4)(d) only arose after the service of the enforcement notice, some 4 or 5 months later. The position adopted by the Forestry Commission wasn't officially made clear until 2021, and after some preliminary correspondence with a junior officer by a senior officer on the 1st of April. It is, in any event, one of those cases where there is we say there's a continuing state of unlawfulness. It isn't a one-off decision. It is a continuing effect because the consequence of the Forestry Commission's opinion or view of the law is that for the period of 10 years stipulated in the condition 2 of the felling licence and the enforcement notice, there is a continuing duty to maintain the restocked woodland regardless of the grant of planning permission, which fully takes into account the tree felling and preservation issue. So it being a continuing state of affairs and potential continuing unlawfulness, we preonate what Mr. Justice Carr said in the Fire Brigade's case, where you have a continuing state of unlawfulness. and it's one which isn't determined simply by attacking a specific decision. That is simply an exemplification of the stance of the Forestry Commission. Having said I was going to deal with it last, I've now.
Well, right.
I've
So
now
that's
dealt with it.
it's as simple as that.
Yes.
You submit.
Yes.
Yes.
It's
All right. Understood.
contrary to what was thought below, it isn't a challenge to the enforcement notice. We couldn't say at the time that the site was immediately felling of trees was immediately required because a detailed planning permission wasn't granted until later, after the service of the notice. We think, as a matter of course, the Forestry Commission were too gung-ho because they knew full well from the beginning what we were doing, but nonetheless, that is what they did. And the question is what the consequence is of what they did and whether it can be unwound.
So that presupposes, does it, that it's an implied obligation on the part of the Forestry Commission to withdraw the enforcement notice?
My Lord, I put it in two stages. They have, contrary to their assertions, we say there's an implied power to withdraw, but that power to withdraw should be exercised in favour of withdrawal where you have a planning permission that comes within section 9.4d, because it is, we say, self-evidently the intention of Parliament that such planning permissions not be subject to the licence regulatory regime.
So the second stage turns a power to withdraw into an obligation to withdraw.
It's a question of the facts, but in this case we say the facts are clear, at least so far as the detailed permission is concerned.
Well, is it?
So is the answer to my question?
Yes. Sorry, I'm sorry, my Lord.
That's right. No.
Sorry, I'm cutting across. Forgive me. You say it's an implied power, then, in answer to my Lord. Is there another way of putting it, which is that not to withdraw would be unreasonable and unlawful? Is that the same thing?
If you add those two stages together, then yes, it would be irrational or perverse not to withdraw to the extent that the planning permission has been granted, which fulfills the requirements of 9.4d.
Right. All right.
And although it appears, certainly from a learned friend skeleton argument, that there appears to be some view that there's a dispute between us as to what immediately required in the provision means, in my respectful submission, there isn't. We accept that outline planning permissions cannot immediately require because you need reserved matters approval or a detailed permission in order to proceed. And we take no issue with the guidance from the Forestry Commission, and we put two examples of their guidance into the bundles. And we accept the position that outline planning permission is not of itself enough, although in the present case, the outline planning permission made it perfectly clear what was coming down the road in terms of tree felling, because there are detailed conditions which, once reserved matters are approved, will clearly...
I mean, there are different circumstances with an outline permission.
There are.
It can be a pure outline.
It can.
Or it can be an outline that has certain matters determined now,
Indeed.
and only certain other matters reserved. Yes. The matters that might be determined now can include siting.
Yes.
So if one knows, because it's fixed, where the building is going to go, and it's going to go where the trees are, then that's a different situation from not knowing where the building is going to go.
Indeed.
So it will depend on the circumstances.
It will, and I make it clear straight away that this is not a case where there's an illustrative master plan that was approved, but the intention of my clients is to put in the infrastructure for which it has the detailed permission, and then to sell off plots of the land for individual developers to develop themselves, and so they will be responsible for putting in the remainder of the reserved matters application.
But the upshot of what you've just submitted to us, I think, is that you're submitting to us that we do not need to determine the meaning of the words immediately required.
No. Perhaps we go to the statute and just look at the provisions. Yeah. Could I, if your lordships would go to the authorities bundles, tab 1, pages 14 to 15.
Thank you.
You have the primary requirement for a felling licence by the appropriate forestry authority, which in this case is the Forestry Commission, required for the felling of growing trees unless under the following provisions of this part of Act, this subsection is expressed not to apply. Subsection 4 provides 4 particular exclusions, of which D is the relevant one, immediately required for the purpose of carrying out development authorised by the Planning Commission. And of course, the original Act referred to the 1962 Planning Act. That was amended to refer to the current Act. As my skeleton argument anticipates, of course, the concept of planning permission changed somewhat from the original provision, because in 1962 the concept of outline planning permission in reserved matters didn't exist, because that was only introduced in the 1968 Act in provisions which are now found in section 92 of the Town and Country Planning Act. But for present purposes, unless the court wishes me to go through the detail, as set out in the skeleton, the consequence of section 92 and the grant of a wholly outlined permission is that you require reserved matters approval of the details before you can proceed with the development.
Yes, sure.
And as the Court of Appeal said in the Fulford case a couple of years ago, as again referred to in the skeleton argument, it is the composite of the outline permission and the reserved matters which constitutes the planning permission authorising the development.
That's been the law for some considerable time.
Indeed. There are a number of cases to similar effect, but that seemed to be the most up-to-date authoritative.
No, that's very, very helpful. And we've got Fulford, haven't we?
Yes, you do.
Yeah. Right, fine. Thank you.
Just to make good the point that the planning regime is intended to trump the licensing regime, you've also got section 15, which deals with trees which are subject to tree preservation orders, which are made, of course, under planning powers, not under forestry powers. And essentially, under section 15, the forestry powers are subordinated, because either the Forestry Commission hands over a consent to fell or to thin TPO trees, or it decides to proceed itself. And if the planning authority objects, then it must refer the matter to the minister to deal with under the Planning Act.
Sorry, which provision?
This is section 15, page 21 of the bundle.
I'm in the wrong place. Yeah.
You see section 15.1.
Yeah.
The appropriate forestry authority must notify the TPO authority, which will be the planning authority, and then in any event it may refer the application to the planning authority, but under subsection 2, where the planning authority objects, then the forestry authority must refer it to the minister, who will deal with it under the Planning Act. So again, it shows the subordination of the felling regime to the planning regime. And my Lord, as I've set out in my skeleton, there's a good reason for this. The Forestry Commission has a relatively specialist and narrow remit, whereas the planning authority is looking in the public interest at a whole series of issues, which includes the protection of trees, enhancement of biodiversity, and such other matters. So issues about sustainability, amenity, the preservation of trees and habitat are all matters which are subsumed within considerations under the Planning Act. And we put in the National Planning Policy Framework, and I simply refer the court to paragraphs 131, 174 and 180 for indications as to the breadth of those planning powers. The NPPF is at tab 7, and those paragraphs are at pages 195, 196 and 197.
Thank you. You don't want us to look at those?
No. I don't think there's any dispute that preservation, felling, replacement, protection of trees is all part of the normal planning function.
In the normal operation of the planning system, if I want to develop my land, which has trees on it, I have to make an application for planning permission.
Indeed.
And I can't proceed without exposing myself to enforcement action unless I get that planning permission.
Correct.
In the consideration of my application for planning permission, the local planning authority will consider the impact of the development on the trees in the light of its own policies, if any, and in any event, these passages of the NPPF, and may or may not grant planning permission.
Indeed.
It may refuse planning permission because the effect of the development on the trees or the woodland, whatever it may be, would be unacceptable.
Correct.
That's the normal operation of the planning system.
Or it may strike a balance and impose conditions for the removal of some of the trees and then the enhancement of others.
It may.
And indeed, it's what it did in this case.
But that's what the planning system does, properly operated.
And whilst the Forestry Commission has a remit for the protection of trees, amenity, sustainability, biodiversity and the like, its functions are entirely subsumed within the Planning Authority's functions as well, from the point of view of the Planning Acts. The Forestry Commission, on the other hand, has no function or expertise relating to the wider public interest issues which are engaged when planning permission is applied for to a planning authority. So it doesn't have the ability to take the broader perspective and the broader public interest, which doubtless is why Parliament exempted the planning permissions and felling under Section 9(4)(d).
Well, what would you say to the proposition that it wouldn't need to have such a broad remit if the authority which does have that remit gets the opportunity first of deciding whether planning permission should be granted or not?
If the planning authority has that remit, the Forestry Commission only needs to be involved if it's outside the planning regime.
Yeah, because if these two statutes operate, as it were, in sync, it's planning first, felling later.
Except in cases where, as here, the landowner wishes to start the felling operations in advance of the immediate requirement for logistical reasons. So it can start looking to sell the land off, although having planning permission, outline permission at the time, and having the intention of getting reserved matters approval.
Well, you say logistical. I mean, in truth, it may be logistical, but it's essentially commercial, isn't it?
Yes, of course.
Yeah. All right.
While I have the Forestry Act open, can I ask the Court please to go to pages 32 to 33 of the bundle, the enforcement provision.
Thank you. Yes. Yeah.
Section 24 is the power to serve an enforcement notice if the works required by virtue of the imposition of conditions on a felling licence are not carried out or the felling directions are not complied with. A is the relevant one here. And then it allows a notice to be given. And I draw attention to the fact that the power to serve an enforcement notice is just that. It is discretionary. May give to the persons responsible a notice. So there is no duty to serve an enforcement notice. And that's relevant, in my respectful submission, to the question as to whether there's an implied power to withdraw or modify as well. And then there are powers to specify what should be done to remedy the default.
I'm sorry to interrupt you again, but it's relevant, very much relevant to what you're submitting to us at the moment. Maybe you're coming to this, and if you are, just say so. Are there other areas of the planning system in which the courts have held, one way or the other, whether there is an implied power to withdraw?
There is the case that we put before the court is the judgment of Mr. Justice Richards, as he then was, under the Service of Noise Abatement Notices, which have a similar structure, and that is to say, notice served. If there's no compliance, then there are criminal penalties.
And that case is called
Everett.
Everett, yes.
And that is in the bundle. The judgment of Mr. Justice Richards is at tab 10, and the Court of Appeal approving his judgment is at tab 11. I'll come to that.
Yes, fine. You needn't go there just yet.
Yeah.
Fine.
And I just draw the Court's attention then, in connection with that point, 24(4 is the imposition of the criminal penalty for non-compliance with the terms of the notice. And it's a fine not exceeding level 5.
What's level 5? Matter of interest.
Lord, I had a feeling you might ask me that, and I forgot to look at it. But
no, don't worry. I mean, I have a vague memory last year of doing one where the fine was astronomical, quite rightly.
I think level 5 is quite high.
Yes, fine.
I can check it.
No, don't worry. We were talking hundreds of thousands of pounds from record.
Potentially, yes.
Yeah.
And indeed, with tree preservation orders and breaches of those, the fines are now astronomical as well.
Quite right.
And of course, this also triggers the possibility of the Proceeds of Crime Act, and indeed that was drawn to our attention in the correspondence with the Forestry Commission.
Yeah.
So there is jeopardy in not complying with the notice. Section 25, subsection 1, is the right to appeal, but it's only on two very narrow grounds: either that the works have in fact been carried out, or that the steps required by the notice are not required by the conditions.
So if there's a mismatch between the original conditions and then what the enforcement notice says.
Yes.
Yeah.
So it's tied very much to the notice and the conditions. There is no right of appeal, for example, to argue that there's been a material change in circumstances, or that the
Well, that wouldn't be an appeal.
no, it wouldn't. It would be a new application or an application to vary. But Forestry Commission says in its guidance, not only can't they withdraw an enforcement notice, they can't vary a licence either. There are other ancillary provisions which I don't think I need to trouble the court with.
Thank you very much.
Lord, at that point, I'd like to take you to the planning permissions and to the felling licence and the enforcement notice.
Right.
You'll need the supplementary bundle, volume 1, tab 6, starting at page S48.
Thank you. Yes.
This was the outline permission granted on the 1st of June 2016, and as in the skeleton, I drew attention particularly to condition 4, which required the development to be carried out in accordance with a number of plans and documents. Of course, the reserved matters, condition I should have drawn attention to is condition 1. But condition 4 includes a number of relevant documents so far as the issue of trees is concerned. If the court looks down 8 items, there's an illustrative master plan ending 330A, 18th of March. There is 3 below that, vegetation removals plan, 26th of February, and then there are various, there's an advanced vegetation protection plan. Can I show you those 3 plans?
Yes.
Tab 6C is the vegetation removals plan, which is required to be complied with when the permission is implemented. S79. And you'll see the site boundary outlined in red, and an area of green which is cross-hatched, which is noted as coniferous plantation, woodland to be removed. There's also hedgerow to be removed, but also there's other vegetation, there is broadleaf woodland to be managed, which is the dark green, and then the hexagons are conifer plantation to be enhanced towards broadleaf woodland. So there are felling requirements, but also enhancement requirements.
Yeah.
Tab 6D, page 80, S80, is the requirement for fencing to protect those areas which are not to be felled, which you can see correspond with the felling areas and the non-felling areas on page 79.
Yes.
And the illustrative master plan is at tab 6E, page S81, which shows you the proposed layout, but it is only illustrative at this stage.
Yeah.
There is also, if you look at the list in condition 4, the penultimate item on page 50, right at the end of condition 4, there's a woodland management plan referred to 4th of April 2016, version number 4, and you'll find that at 6B.
Sorry, the drawing's called the...
It's a document, the Woodland Management Plan, version 4. The condition was to comply with plans and documents.
Yeah.
And you'll see, it's page 60.
Thank you.
And you'll see it's stamped received 4th of April and it says version number 4 at the bottom. It includes some of the plans that the court has just seen, but it sets out the management proposals, including the enhancement and protection of habitats and the like during work. So the details don't matter so much as the fact that it demonstrates the local authority looking in detail and conditioning both the removal and the protection of certain parts of the woodland and habitats within the woodland. For example, bat runs.
Bat runs?
Yeah, some of the woodland was used for bats moving from one part of the site to another.
Yeah, no, it's just the idea of bat runs as opposed to bat corridors.
I think I was paraphrasing badly.
Yeah, I understand, I think.
Yes. It comes up again with the roads because they need to amend some of that. The felling licence is applied for in 2018 after the grant of outline permission, and you'll see the covering letter at tab 8, page 90, and the licence itself starts at page 91.
The application's at 82, I think.
It is. Yes.
So there's an application at page 82.
Tab 7, yes.
And then the licence itself is at page 90.
Yeah. Well, the covering letter's at 90. The licence starts at 91.
Yeah.
So 19th of October
2018. Expiring on the 19th of October 2019. You've got to do the felling within a stipulated period.
Yeah.
And you then have a schedule of both felling and thinning, 92. And then the condition which causes the difficulties at page 93, the restocking conditions. There is a specification for restocking in terms of percentage species. And then at item 2, and this is the one that causes the real difficulty, for a period of 10 years from planting, to protect against damage and to weed them, to replace losses, and to maintain the replanting for that period.
Presumably, paragraph 1 required both A and B to be done before the 30th of June 2020.
Yes. It wasn't done before the 30th of June, which, as you'll see, which is why the enforcement notice was served.
Yeah.
For reasons which I'll show you in a moment. There's a plan which goes with the specification on page 92, at page 97, and effectively you'll see areas marked 1A and 1C, and 2A and 2B. 1C and 2B are the areas for felling, and the other areas in brown are for thinning.
So 1C...
1C and 2B
yeah,
are total felling, and 1A and 2A are thinning.
Thank you.
And then there's a map on the following page, page 98, the areas for restocking, which are the areas of total felling.
Yeah.
And it won't have escaped the court's attention that that substantially overlaps with the areas shown for felling on the grant of planning permission. Not identical, but substantially.
Yeah.
If you compare with page 79.
It's more or less a replacement of trees.
It is. prior to the grant of the licence, there was a meeting between the Forestry Commission and the arboriculturalist representing Arnold White, and that's at tab 9, page 99 following. And you'll see from paragraphs 1.2 to 1.3 on page 99, it was put very much in the context that it was a complex application due to the planning application issue running alongside and during the large size of the areas, etc. And at that stage, there was no certainty as to the future prospects because detailed permission had yet to be granted. And you'll also find, curiously, at 3.1 on page 101, dealing with large dieback and Gavric copse, a felling licence would be needed. There is no requirement to undertake work agreed under a felling licence, but once implemented, there's a need to replant. However, a planning permission which then comes into force overrides the need to replant. That was the understanding at the time. That's for the court whether it was a correct understanding, of course.
So where is this?
3.1 on page 101.
Yes.
Part of the discussions of the meeting.
Well, who was saying that?
It's not clear, but it's fair to say that that was our arboriculturalist understanding, because he says the same thing in an email at page S105. An email beginning on S104 on the 22nd of October.
This was an agreed note of the meeting, was it?
I think it is our note of the meeting. I don't think it's ever been responded to by the Forestry Commission.
But was it sent to them for their approval?
I don't think I can say that.
No, right.
It's just our record. But as you'll see from the top of page 105, that was certainly the arboriculturalist's understanding.
Yeah.
Then at tab 11, page 107.
So it's a slightly odd situation, isn't it? The appellant applies for a felling licence.
Yes.
Gets a felling licence.
Yes.
With very clear conditions.
Yes.
The response being on page 104, good news, we've now received
Yes.
the felling licence with the conditions attached. And obviously there wasn't any quibble about the conditions because they were clear, as you've indicated.
Yes, it wasn't.
So when you say they caused difficulty, they've now caused difficulty because of the potential understanding, misunderstanding of how the two regimes interacted. But it's
right.
It's an oddity of this case
Yes.
that the problem all stems from something that on the 22nd of October 2018 was regarded as, quotes, good news.
Yes, it was good news because we wanted to start felling in advance of the grant of detailed planning
Yes,
permission.
but there was no doubt about what the conditions said.
No, absolutely.
And so it does become a pure point of whether people's understanding were right.
Yeah, well, and indeed whether it's right to say that there's no implied power to amend the situation on the part of the Forestry Commission.
Yes, but if there isn't if 9.4 isn't in play, you might not get into that.
No, well, 9.4D, we say, indicates Parliament's intention that the planning regime should take precedence to the felling regime, and we say that that isn't something that's just a one-off at the beginning. It's a continuing one, because if you... Sorry, my lord.
Okay, no, that. Can I just explore that with
Yes,
you,
of
since
course.
you've touched on it? Because I've been... Obviously, 9.4 wasn't a point that arose directly in front of the judge, because I think she somewhere says it was common ground that 9.4 doesn't apply. You look puzzled. It's in the core bundle. I think it's
Yes,
paragraph 12 of the judgment.
Page 60.
Page 69.
9.
Last
Para 12.
it has no bearing on the validity of a felling licence or an enforcement notice under the Act, save as provided for in Section 9.4, an exception which it was common ground does not apply in this case.
That was the point I made earlier, which is it couldn't apply at the grant of the felling licence because there wasn't a planning permission that immediately required felling, and nor at the date of the enforcement notice. It arises after the enforcement notice and after the felling licence.
But do you say that 9.4 applies to these circumstances, or do you say you rely on 9.4 not directly but indirectly as demonstrating, as I think you put it earlier, that the forestry regime is subsumed in the planning regime?
It's intended to be subordinated to the planning regime.
Yeah. So is that why you rely on the exception, as it were, indirectly?
Yes.
Because you can't rely on it directly, can you? Because there was a felling licence, and 9.4 is an exclusion if there isn't a felling licence.
Yeah, and we couldn't rely upon it at the time to say, because if 9.4 had applied, we'd have just gone straight ahead and felled and said we have a planning permission, but we didn't have a relevant planning permission for those purposes.
So you accept that 9.4 does not apply directly,
Correct.
because that's an exclusion in circumstances where you don't need a felling licence.
Yes.
Here, you applied for, got, and were pleased with the felling licence.
Yes.
So therefore, 9.4 can't apply directly. So I've assumed, hence the judge's comment.
Yeah.
But you say you can rely on 9.4 indirectly to suggest that the the forestry regime is subordinate to, as you put it, the planning regime.
Yes.
And that's the sort of the kernel
It is.
of the point on 9.4.
It is.
Thank you very much.
It's indicative, along with Section 15 with tree preservation orders, that Parliament intended, as I've said, that one regime was subordinated to another. And if one asked yourself a question at the time that the detailed planning permission was granted, would a felling licence have been required? The answer would be no. And therefore we say it produces a perverse set of circumstances if the Forestry Commission cannot review that in the light of Parliament's obvious intentions.
Yeah, thanks very much.
The detailed permission for the infrastructure is at tab 11. All I need to do with respect is point out that there are other plans which are conditioned by this, and another tree management plan at tab 11C, and a design and access statement which explains what is being done. In particular, I think the most helpful is at page S140, which explains what is being done with the detailed proposals. And the plans demonstrate that this doesn't cover the whole of the area of the felling licence, it covers the areas where the infrastructure is proposed. You'll see at S140, the second paragraph, proposed felling areas are designed to allow the necessary width to construct the proposed works, allow for ground levels to be graded, etc. Areas are to be kept to the minimum required, retain a sufficient tree root zone to support retained trees and ensure their stability is factored in.
So when we talk about infrastructure,
Roads and drains.
I was going to say
Roads and
drains, yeah. Yeah.
It also
The roads wouldn't be serving anything specific
well
now, because the plots would then be sold off, and then individual developers would build, if they got permission, what they wanted on the individual plots, the roads having been put in.
Yes, the witness statement in support explains what was being proposed. What Arnold White was proposing to do was to get in the structure of the development and then sell off plots that could then be built off the infrastructure that had been put in.
I'm sorry, Mr. Elvin, I'm being slow here. What was what was the proposed felling as at March 2019? It's the felling pursuant to the licence had already happened, hadn't it?
No, it was talking about the proposed felling for the purposes of the infrastructure.
So this is different felling.
It's a more limited form of felling at this stage.
No, but is it felling of trees that are still standing in March 2019, or trees that have gone?
It's felling of trees that are still standing.
Right.
And indeed, I believe...
just not quite sure what that's got to do with the trees we're concerned with.
Because the requirement to replant and to maintain prevents that being done.
Right. Okay.
Detailed consent for the infrastructure, so if you need to.
And the next stage, which overlaps with that planning permission, is the service of the enforcement notice, which is tab 14, page S186. It's the covering letter.
We're into volume 2 now.
Yes.
Yes, sorry, page again?
186 is the covering letter.
Yep.
So the permission we were just looking at
Yes.
is the 14th of September.
It comes
We're
up.
now going back in time to the enforcement notice, which is 28th July.
So when it makes the point that the enforcement notice was served before there was a planning permission immediately requiring.
But after the date in the licence,
Yes.
which was 20th of, was it the end of June? Yeah, 30th
Yes.
of June 2020.
Yes.
Yeah.
So the period for compliance with the original licence had expired. The Forestry Commission, quick off the mark, refer to that in this letter and serve an enforcement notice. The notice begins at page 188, tab 14, dated the 28th of July. And the court will see at the foot of the first page, it recites the condition with regard to restocking, and then the second part, the 10-year period of replacement and maintenance. And it attaches as plans. Plans the court has already seen attached to the felling licence, page 190 and 191. And indeed, it attaches the felling licence. This, following the grant of permission in the autumn, this led to a query from my client's instructing solicitors, for my clients at tab 15, where on pages 200 and 201, seeking assurance that given the grant of the detailed permission, it wasn't necessary to restock in accordance with the notice, pointing out, as was thought, that the requirement to restock those areas is redundant. That's at the top of page S201.
Sorry, you just the first point you made just now, is that bottom of 200?
That's the bottom of 200.
Yeah.
And then over to the top of 201.
So this was being written on the 13th of January 21.
Yes. And there was initial email response from a regulations manager, Ellie Littlejohn, 202 to 203, 15th of January.
So was there just a gap then? If you go back to the beginning of the letter,
Yes.
we refer to the licence in your section 24 notice dated the 28th of July 2020.
Yes.
And this is nearly 6 months later.
Yes.
And what's been going on in the meantime?
They've been trying to sell the site, or sell parts of the site, and I can find it.
Right.
And problems have arisen, although the purchaser doesn't pull out until early in 2021.
So is there, as it were, radio silence for as
Yes.
between the applicant and the commission
Yes.
for 6 months?
Well, from October to, because nothing could be done until the detailed grant of permission.
No, it's not. When I say radio silence, I simply mean there wasn't communication. It's entirely neutral.
Yes, let me just check
concept.
the witness statement. I don't think there's any relevant correspondence in that period. No, nothing of significance occurred.
Can I just check, Mr. Irving, just
Yes,
looking
of
at the top of page S201.
Yes.
Is it your case that the requirement to restock was redundant before the detailed consent of September 2020?
No.
But the restocking was to have been completed by the end of June, wasn't it?
Yes, but
Well, if it wasn't redundant, was it not valid?
it's why, in response to my Lord Justice Coulson, I said that we accepted the enforcement notice was valid because at the time there wasn't a planning permission which immediately required felling. That only occurred when the detailed permission was granted. So the enforcement notice we could not challenge at that stage, nor could we appeal it because of the limited grounds of appeal.
No, but you could comply with it
Yes.
and didn't.
No.
And why not? If it wasn't then redundant, why was it not complied with?
Because it was because of the
It's going to be redundant.
because of the understanding that we were moving towards getting detailed planning consent,
Right.
and the understanding was that if we subsequently got a planning consent which would have qualified within 9(4)D, it would no longer be relevant to consider the felling regime. And that was rapidly approaching. And as you've seen, the permission for the infrastructure was granted on the 14th of September.
Right, thank you.
Before going, I'll take you through the correspondence and I'll go to the Forestry Commission's guidance. The email of the 15th of January essentially says that the thrust of the advice is at the top of 203, that the duties under the licence and notice remain, and the manager says the Town and Country Planning Act has no provision which neuters or overrides felling licences or notices. Doesn't prevent the local planning authority from granting planning permission if it's so minded. Well, that's true, but nothing to the point because, of course, no planning permission could be implemented. Your client should be aware that if they or any subsequent owner enact planning permission, I think she means implement, which renders it impossible to comply with the conditions of the enforcement notice, the Forestry Commission will not accept this as a reasonable excuse for non-compliance. So, in other words, the 10-year period is enduring, regardless of the regardless of the existence of a planning permission, and the Forestry Commission are asserting that you will be in breach and therefore liable to prosecution, as you see in the next paragraph. That position is then challenged by Mr. Williams.
So that's the position that you refer to at paragraph 24 of your skeleton, where you say this was a clear statement that the Forestry Commission considered that the licence in section 24 notice took precedence to any planning permission and would prevent its lawful implementation.
Well, we have a short period of investigating whether that's endorsed by by senior officers at the Forestry Commission.
Well, you go on to say this analysis has been reaffirmed
Yes.
by the Forestry Commission on the 16th of February and the 1st of April.
Yeah.
So their position was clear as at the 15th of January.
And clarification was then sought from the head of the Forestry Commission on the 3rd of March, page 220, which led to the senior officer, the National Regulations Team Manager, on the 1st of April, affirming that position. And that led to the collapse of a potential sale, as might be imagined, because they weren't prepared to take the risk given what the Forestry Commission was saying. The position of the Forestry Commission so far as saying once everything is set with a felling notice and an enforcement notice, then regardless of subsequent grants of planning permission, we have no power to change this. It's not something which is foreshadowed in the Forestry Commission's own guidance, and I just draw the Court's attention to that. I appreciate it's not determinative. Tab 29 of Volume 2, beginning at page 267, is the tree felling getting permission, which is the main guidance on the licensing provisions.
I'm very sorry.
Tab 29.
Tab 29.
Thank you very much, my lord.
Page S267.
Thanks very much.
And which part do you want us to look at?
I was just going 273. It sets out the exemptions, and development is at 2.7. We don't take issue with that because it makes the point that outline permission is not sufficient to demonstrate it's immediately required, which I've already accepted, as the Court knows.
So, and that's also consistent with minors.
I'm sorry, my Lord.
That is also consistent with minors. M-Y-N-O-R-S.
Yeah, sorry, Charles Minors.
No, sorry,
My mind went in an entirely different direction.
Don't worry. I understand that. But he that's what he says.
Yes.
But he doesn't ascribe that to any authority or cross-reference it. He just has that statement.
My Lord, I accept it as a proposition of law for the simple reason that you cannot implement a wholly outline permission until you've got reserved matters. So it can't be immediately required.
So whatever else happens, we'll be able to give Mr. Minors a footnote reference that
he can have the
he is right. He is right.
And what also appears in the guidance is penalties for felling without a licence, which doesn't take matters any further. However, what you don't find here is any indication that if there is a subsequent grant of planning permission, what the Forestry Commission will or will not do. It's not, the position that you find in the correspondence in 2021 is not heralded in this guidance note, and indeed it's not a point touched on by Mr. Minors either. There's also online guidance from the Forestry Commission at tab 30. It has felling trees on development sites 297, and it just makes it clear that you've got to explicitly demonstrate the requirement for felling in any planning permission and supporting the position on outline planning permission. Again, there's no guidance which suggests that the Forestry Commission will refuse to consider the subsequent grant of planning permission, which would qualify under section 9.4d. So the points which appear in the correspondence are new points. And indeed, in the context where there'd already been a meeting before the felling licence, as you've seen in 2018, where the Forestry Commission's attention was drawn to the fact that this was being done in parallel with a planning procedure.
Well, you say there's no guidance either online or published otherwise indicating that the Forestry Commission in these facts and circumstances would do what in fact they did.
Yes.
Is the point.
Yes, indeed.
Right.
My Lord, I'm not going to take you to the letters before claim and the response because it sets out the parties' relative position. Those are the key documents so far as the appeal is the application for judicial review is concerned.
All right, that's very helpful, thank you. Do you want just to draw breath for a moment and let us put away anything we don't need to have in front of us now?
Yes. Thank you.
And the next part of your submissions is what?
Is to deal with the implied power,
Right.
which I've already substantially foreshadowed in my initial submissions.
Okay.
Our submission is essentially this, that where there is a material change in circumstances so that tree felling which has been licensed falls within the scope subsequently of a planning permission which would qualify under 9.4D, or perhaps other material changes arise, the Forestry Commission does have an implied power to withdraw its enforcement notice, and indeed should do so if it's clear that an exemption would then apply. Because, in my respectful submission, there can be no good purpose for requiring continued compliance with a notice for an extended period when the conditions set by Parliament had then been met and the position was then regulated by the planning regime. As I have already submitted, the power to serve an enforcement notice under section 24.2 is a discretionary power. That is, in my respectful submission, a good starting point if there is a discretion to serve, to consider the existence of the discretion to modify or withdraw. Because
why did Parliament, well, you're going to say perhaps we don't know, but why would you suggest Parliament left out an express or explicit power to do this?
My Lord, it was relatively early days in the planning regime, as I've already drawn attention. Although the current Act was substituted in Section 9, of course, the statutory framework was set up at a time when there were no reserved matters applications, no outline permissions. And it perhaps had not occurred to Parliament that the situation might arise where the question of the initial authorisation of the planning permission and its subsequent approval, so that it became immediately required at a date later than the grant of outline planning permission, occurred. So far, I appreciate that hasn't directly answered your question.
It is an answer, undoubtedly. We don't know unless we consulted Hansard.
Well, it won't help you because I've done that, just in case.
Anyway, which bit of Hansard? It wouldn't have been when the forestry.
No, it would be.
It would be at some point when the amendment came in, referring to the 1990 Act.
As far as I'm aware, it was one of those purely technical schedules to the Town and Country Planning Act, which substituted earlier references to it would have been the 71 Act before that, and etc.
68, 62, 47.
Well, it started with 62. But we've been unable to find anything that would either be admissible or indeed of any assistance whatsoever. And of course, in those days, there weren't any explanatory memoranda to go along with the Acts of Parliament, which might help you understand the purpose. Yes, well, quite.
Yes, life was simpler then.
Yes. But it do I assume, correct me if I'm wrong, but the fact that this point has arisen in this way in this case, and we're now considering it, rather implies that this isn't something that has caused massive difficulty across the piece. I mean, it doesn't seem to have been a point that's arisen before.
There are very few cases on forestry felling licences. I think we put in another two just to show it's questions of fact, but I don't think it assists the court at all.
The ones about gardens.
Ones about gardens.
I've looked at those. I'm bound to say I struggled to see how they related to this.
Well, it was in part just to show the court these issues don't often arise anyway.
Okay, fine. Well, that's good enough. That's good enough for me.
Yes.
Point.
It was a sort of slight attempt to try and find anything of assistance other than Mr. Miners.
Yeah.
But the point is this: if Parliament's purpose is, as it clearly was, to subordinate felling licences to the planning regime, it can serve no sensible purpose consistent with that parliamentary objective to allow a notice to continue regardless, and effectively to render the land substantially undevelopable for the standard restocking and maintenance period of 10 years. That period is standard. You'll see it in the planning guidance. I didn't take you to it, but 10 years is the standard period. So although the officer blithely says, well, it doesn't stop the grant of planning permission, it does actually stop the development of land, and what developer is going to apply for permission that can't be developed? We say, therefore, it serves the purpose of the Act to have an implied power to withdraw, taken with the power to serve in the first place. It does not deny the fundamental requirements of the Act. A licence is still required unless permission exists in the terms required by 9(4)(d). And it serves the purpose by not leading to absurd results, that is to say, unimplementable planning permissions, when Parliament clearly intended that planning permissions shouldn't be obstructed by the requirement for felling licences.
In these circumstances, it's not possible, or is it possible to apply afresh?
Well, no, because you've still got the correspondence says we can't vary the notices, vary the licences as well.
Yes, no, what I'm contemplating is an entirely fresh application process.
Well, there's no point making a fresh application because we rely on section 9(4)(d) so far as the infrastructure permission was concerned. That's the difficulty. We can't even put
So you say there's a kind of catch-22.
There's a catch-22. If you've got commercial, no one suggested bad reasons for wanting to proceed in advance of a slow planning process and start felling to assist the development process, you are caught in...
Right. Well, the catch-22 point, if we can glibly characterise it as that, I did. Do you make that part of your argument?
Yes, there is nothing a developer can do. He can get his planning permission, he can sign his planning obligations, he can sign up to detailed woodland management proposals, as you've seen, but all for nothing because the 10-year condition prevents the land being developed for 10 years. And that cannot, in my respectful submission, be within the public interest represented by the provisions for the exemption that Parliament created. Can I go take your lordships to the Everett case?
Yes. First instance first?
First instance first. And we'll avoid the cases on gardens. Tab, authority bundle tab 214.
Thank you, yes.
This was an abatement notice under the local authority nuisance provisions in the Environmental Protection Act, and this was a case where the nuisance had abated and the local authority wanted to withdraw its own notice, and that was challenged. And the key passages were, Mr. Justice Richards deals with this, again on page 227, internal report page 105, at letter D.
Yeah.
So in those blissfully innocent days of no paragraph numbers on judgments. And you'll see the submissions made against the implication of the power, letters E to just above H. And then Mr. Bowes for the local authority sets out his submissions. And what Mr. Justice Richards says on the next page at letter D is, I accept submissions in the absence of an implied power to withdraw an abatement notice. The enforcement provisions would be unduly rigid. It seems senseless that an authority should be unable to withdraw an abatement notice which, for whatever reason, it no longer considers to be appropriate. It's particularly unsatisfactory that the recipient should remain subject to it, and by reason of a failure to comply with its requirement should remain in breach of the criminal law in circumstances where the local authority doesn't consider the notice to be appropriate and has no intention of bringing a prosecution. It's consistent with and serves to promote rather than to undermine the legislative scheme, and I see no difficulty in implying such a power. Now, I appreciate there are differences between those circumstances and this. The authority there wished to withdraw the notice, but the question is whether here the Forestry Commission should have been considering withdrawal of the notice, and in my respectful submission, the key questions of whether it promotes rather than undermines the statutory purpose is an important one, given A, the intention of Parliament with regard to the primacy of the planning regime, and secondly, the fact that the decision to proceed with enforcement is discretionary, and of course, thirdly, Of course, a decision to prosecute is also discretionary, but that without the amendment or withdrawal of the notice, depending on the circumstances, the party is unable to develop the land, and if not compliant with the notice, is subject to criminal prosecution, as indeed the Forestry Commission has said explicitly. And although my learned friend submits that this is inconsistent with the regime, in my respectful submission, that is no more than to restate the obvious, which is that there's no express power to withdraw. And it's clear from Mr. Justice Richard's judgment that that was not a determinative issue. He looked at whether it was consistent with the regime to have a result which ran contrary to sense. And in my submission, the same applies here for the reasons I've given. The Court of Appeal didn't spend a great deal of time dealing with this issue. Lord Justice Mummery agrees with it, pages 239 to 240. They spent most of their judgments dealing with other issues in the context of the abatement notice. At 239 to 240, Lord Justice Mummery agreed and says the council clearly had an implied power to withdraw the notice and exercise that power lawfully. And neither of the other members of the court set out a disagreement, but in fact agreed in substance with Lord Justice Mummery. So the Court of Appeal doesn't add to it other than the weight of the Court of Appeal's adoption of Mr. Justice Richard's reasoning.
Does Lord Justice Buxton deal with this question?
No, he doesn't.
So there's really no further discussion on it.
No, it's that short passage in Lord Justice Mummery's judgment.
So on your submission, that's authority for a proposition that a notice can be withdrawn. It doesn't, of course, deal with the question of your second point, because there the council wanted to withdraw it. So the second point didn't arise. It's that second point that obviously matters for these purposes, because you have to say not only is there a power, but there is an obligation.
Well, can I put it this way? The reason that a power should be implied is for the better operation of Parliament's intentions in setting up the regime. If the reason for triggering a review in this case is because of the position with regard to the detailed planning permission and section 9.4, the purposes behind 9.4D, then that itself gives you the answer to the second part of the question, which is, well, if this is a case where a planning permission has now been granted, which immediately requires, etc., which we say is the clear position after the infrastructure permission of 2020, then little other conclusion could be reached, we submit, rationally by the Forestry Commission. They've denied the power exists, so they've never addressed the issue. But in my respectful submission, there would only be one rational answer to that particular question, given 9.4D and the purpose of Parliament in creating it.
So it's the irrational failure to withdraw. Is the way you put it.
When one considers it in the light that if the planning position is as I've submitted to your lordships, it means the Forestry Commission, which has no remit for the wider planning considerations, can, by insisting on not amending its notice, effectively prevent the development of the land to which the notice applies for the period of 10 years. And there is no support for the contention, in my respectful submission, that Parliament had that in mind, because it's giving the Forestry Commission power to override the effects of any planning permission, because the power to grant planning permission is pointless if it can't be exercised. And it's effectively allowing the Forestry Commission in those circumstances to override the view of the planning authority, which is entitled to and does take a wider view of the public interest than the Forestry Commission is able to do.
Is there anything on that last proposition? It may be said, may it? I don't know, that there's a wider remit for a local planning authority acting in the public interest,
yes,
exercising planning powers. But if one was, as it were, drawing a Venn diagram of these powers and functions, would there be anything for which the Forestry Commission is responsible, for which the local planning authority is not responsible?
Well,
in other words, would there be some other part of the remit of the Forestry Commission that is not, as it were, subsumed within the remit of the local planning authority?
No. If,
what's the authority? Just
well, I was going, what I was going to do was to show you the basis upon which the Forestry Commission acts, or at least so far as you can gain it from its own guidance.
Yeah.
If you look, this is in volume 2 of the supplementary bundle, tab 29 again. And I'm going to take you to Mr. Miner's book. It also gives you some assistance on the purpose of the legislation.
Right.
S270, you'll see under Introduction, in large green letters, to protect and sustain England's highly valued trees and woodlands, felling licence is normally required. And then you have in white lettering below that, Government Department responsible for protecting, expanding and promoting sustainable management of woodland, increasing the value of trees and woodlands for society and the environment. We're the regulator for tree felling, responsible for assessing applications and issuing licence. We monitor compliance, etc., and use enforcement action. The sort of issues that they are responsible for are entirely subsumed also within the remit of the planning authority when it is considering the felling, retention and protection of trees.
I've just noticed, and you may have taken this just before, and I didn't notice it, but on 270, I've just noticed a bit in bold about a felling licence. Once it's been issued, it can't be withdrawn, and once tree felling has started, a licence cannot be amended.
Yes. It doesn't tell one, though, about anything about the enforcement notice, though. It's the enforcement notice issue that is of concern.
Well, no, quite. Is that not quite right, is it? Once tree felling has started, a felling licence cannot be amended. This felling licence had the restocking conditions as part of the licence.
Yes, but it's still got to be enforced.
Well, yes, if somebody doesn't comply with it.
Yes.
The assumption that is usually made is that parties comply with licences that are issued.
Unless, of course, there are material changes in circumstances which warrant it.
Well, that then brings us back to the argument. But as I say, probably my fault. I had not realised that the Forestry Commission guidance stated that at the outset.
Yes.
Sorry.
Yes.
Yeah.
But it's the same position, my lord, under planning law in terms of enforcement. The mere breach of a planning permission doesn't give rise to criminal liability. It gives the local authority a discretion in order to take enforcement action. And the authority must make a decision to do that. And it's only once it's taken enforcement action and that has been ratified or not challenged that criminal offences then arise if there's non-compliance. And it's the same two-stage process with tree felling.
So the proposition would be where development proposals are concerned. I'm just writing this down and formulating it for myself at the moment. Where development proposals are concerned, the remit of the Forestry Commission is wholly subsumed within the remit of the local planning authority.
Yes. And can I take you to what Mr. Miners says as well, because that's helpful and proceeds along the lines that I've suggested. It's Authorities Bundle, page 14.
Yeah.
It's the beginning of the chapter on felling licences. Could I ask the court just to read the second paragraph beginning the policy behind the operation of that legislation up to the quotation of the divisional court in the Grundy case at the top of page 444, page 279.
279.
Sorry, the second paragraph on 278 up to the top of page.
Yeah, 278. The paragraph that starts the policy behind.
Correct, my lord.
Yeah.
Yeah.
And it goes down to the end of the first long paragraph on 279.
Case of Grundy.
Yes. If the court would like it, I can make that available. But I suspect it's only the quotation of assistance, which merely underlines the point that I was making earlier, which it overlaps with the same considerations which apply to a planning authority's considerations.
Clearly, the Forestry Commission's remit as a whole extends far beyond development.
But it's the context of the tree felling.
But it's the particular context we're dealing with here. You say that there are no interests, as it were, served by the Forestry Commission's activities that are not present and to be attended to in the planning system.
Yeah. And your Lordship can test it this way. If that were not the case, Parliament wouldn't have then taken the requirement away in the case of 9.4d, nor would it have subsumed the decision-making for tree preservation orders, which of course apply only to the most valuable trees, and given that either to the planning authority or if the planning authority objects, requiring it to be dealt with by the minister under the planning legislation. And that simply underlines the fact that the planning regime is sufficient to deal with these issues.
Mr. Alvin, just help me with this, if you would. 9.4d is concerned with the situation, isn't it, where the trees are still standing?
Yes.
And is that also the position with the tree preservation order point
Yes.
you make?
Yes.
So how does all this work, the subsuming of the one regime within the other? How does this work where the trees have actually all been cut down?
Well, because it's condition 2 on the felling licence. It's the concern here is the obligation not only to restock but then to maintain the restocking, so that with a valid enforcement notice it becomes a criminal offence if you don't restock and then maintain for 10 years. That's the difficulty.
I understand the difficulty. I just would like your help, please. You confirmed that my lord had correctly noted your submission that in this area, at any rate, the remit of the Forestry Commission is wholly subsumed.
Yes.
That in a situation where the trees have already been cut down,
Yes.
aren't the two entirely different situations being considered? The Forestry Commission's remit would have considered, and here did consider, standing trees. The planning authority's remit considers a cleared site, doesn't it?
Well, except that we have to restock, and therefore the point arises again, because restocked, the trees then have to be removed. It's the same as if the local authority has to consider considers, and I showed you lordships the vegetation removal plan, considers both replacement and enhancement areas as well as the removal areas. I mean, the two go hand in hand, and it would, in my respectful submission.
But I'm sorry, I'm obviously being very slow, Mr. Alvin. If the two effectively cover exactly the same territory, what's the commercial advantage which prompted the appellants to start felling immediately and refrain from restocking?
Well, the advantage was they considered that the regime allowed, with the subsequent grant of reserved matters permission, that it would removed the obligation to restock because immediately required planning permissions aren't caught by the regime. I mean, sorry, I'm being reminded, and I should have said this earlier. Arnold White, to avoid prosecution, did in fact restock to comply, and you'll find that.
Yes,
at
I understand
S16.
that. I understand that.
And that was necessary to avoid criminal prosecution, and it's part of the absurdity which I respectfully submit exists, where had they waited, they would not have been in this position, but for good reasons, and their reasons aren't criticised by the Forestry Commission of wanting to proceed in advance of reserved matters approval, because the way the site was going to be developed. They wanted to make the site as attractive for redevelopment as possible.
All right, thank you.
So that is a in that sense a quirk of or a result of the particular way in which this site was going to be developed.
But it's not a particularly unusual quirk, to the extent, of course, my lord, that developers often seek to create what are sometimes called oven-ready sites. That's a terrible term, but but it means that the site has its infrastructure available, and then parcels can be sold off to individual developers.
I follow that, but from a planning perspective, everybody's agreed that outline planning permission is not enough.
No.
And so therefore there is then the question of whether work is done in anticipation of reserved matters approval. And effectively that's what happened here.
Yes.
Which is why it may be difficult to say that there's some one-size-fits-all answer, because if outline planning permission isn't enough, and one can well see why, otherwise woodland would get felled in relation to planning proposals that nobody would have any chance of actually realising.
Yes.
So it is a sensitive, using it neutrally, it's a sensitive area in which, for the reasons that you've articulated very clearly, you want effectively what becomes a non-discretionary power in the particular sorts of circumstances that have arisen here.
To which my answer is, of course, as your lordship will anticipate, that's what Parliament always intended, that if such a permission was granted, it shouldn't be subject to the regime. And the difficulty arises that the regime does not, in any detailed way, seek to accommodate subsequent planning permissions.
That might be ascribing quite a lot to what Parliament intended.
Well, it might be, other than if you start from the proposition that Parliament intended planning not to engage the tree felling licensing regime, hence sections 9 and 15. And you also have to proceed to the proposition which flows inevitably from the Forestry Commission's position, which is even if the trees are fully considered and fully justified in terms of a subsequent planning permission, you cannot then develop the site because the Forestry Commission has imposed a maintenance condition for 10 years. It isn't just a restocking condition which can then be considered in the light of a planning permission. It's a restocking condition and a maintenance condition which it would be a criminal act not to comply with for 10 years.
Yeah.
That's the difficulty.
There are differences, clearly, in the nature of the responsibility, even if the responsibility is coincident. Perhaps. The Forestry Commission has a national remit, doesn't it?
At least in England.
Yes, at least in England. Therefore, its responsibility is, in part at least, to take a national view of woodland and forest.
It's the question of the amenity and other value of woodland in a particular location.
I can't improve on Charles Miners, I think, at the top of page 279.
But it's like... I'm sorry, my lord.
No, go on, yes.
No, all I was going to say, yes, but it may be a national duty, but it has to be applied to the specifics of the locality. And some trees,
of course,
those trees in the locality are also within the remit of the local authority, which covers not just the locality but its whole area.
But what I was getting on to saying was this, partly the force of what my lords have both been saying from different starting points may be that if you have a scenario in which the grant of planning permission is anticipated, I hope I use the word correctly, by the felling of trees, and then there are other planning issues that the LPA decides really should prevail. The trees have gone when they needn't have done. The LPA may say, well, no matter, because we wouldn't have refused on trees, but there may be, and this goes back to my question, there may be, as it were, a broader, more, I hate the word really, holistic view on the part of the
Well, with respect to take those circumstances, there wouldn't be a difficulty in those circumstances, because if the authority said, well, we wouldn't have refused on trees, but we're not granting permission, then these circumstances would never arise, because the restocking condition would then come into play.
Yeah, the trees have gone by then.
No, but they'd be replanted.
And they grow over a long period.
Yeah, but in terms which are acceptable to the Forestry Commission. So if planning permission is never granted,
so there's a logical.
Yeah.
There's a logical override, you're saying, I think.
Is that right? In effect, the tree felling regime provides a separate consenting regime when planning isn't engaged. Where planning is engaged and permission is granted, which includes tree felling, those protections aren't required. It's when the planning regime doesn't engage with the particular issue that the problem arises, either in advance of the grant of permission or because permission's applied for and then refused, and the protection lies in the restocking conditions. But that's not the case here. I mean, the simple difficulty in this case, from the point of view of logic, is that if you take the position, in our case, detailed grant of planning permission, had it been left until that stage, there'd have been no question of needing a felling licence.
No.
And there'd been no question of the imposition of a restocking requirement. But because of the way this works, and because of the Forestry Commission saying we have no power to review this at all, forget the felling licence, but in terms of the enforcement notice, even though they had a discretion to serve it, you're left with an entirely different position, although the planning position would be entirely the same, would be completely the same. And that lack of consistency can't have been intended, in my respectful submission, by Parliament. And I've made my submissions as to the purpose of Parliament in sections 9 and 15.
So, that's it, is it?
That's it. And my Lord, you've got my submissions on delay, because I made them at the beginning.
You made them at the beginning.
Yeah. So unless there are any other matters I can assist the court with, those are my submissions.
Yeah.
Thank you very much, Mr. Ilvin.
Thank you.
Yes, Mr. Simons.
My lords. If I can, my lords, to assist the court, I'll do four things.
Yes.
First, I try to identify very briefly what we say the substantive issue is. Mm-hmm. Secondly, some short submissions on the facts, which of course most of which you now have and have been taken to anyway. Thirdly, some submissions on the legal framework, and then finally, again, pretty briefly, I'll make some submissions on the question of delay.
Right, you are.
So, firstly, on the substantive issue, then trying to sort of characterise it, it's described by the applicant or appellant, the applicant, in the skeleton argument in a number of different ways. It's said at paragraph 4 of the skeleton to be whether the provisions of the Forestry Act can be said to, quote, preclude the carrying out of development authorised by planning permission. My learned friend Mr. Elvin said this morning that the real point is whether, as he put it, section 9.4 has what he called enduring effect. Enduring effect. Mm-hmm. We say that neither, with respect, that neither of those formulations is in fact the issue of principle for the court to decide. That there is an issue of principle for the court to decide, of course, but it's this question of subordination that Mr. Elvin's developed this morning. It arises from a submission that's made at paragraph 70 of the applicant's skeleton, where it said, and the court need not take it out now, but it's paragraph 7070, where it said that the licence and the Section 24 enforcement notice should be, quote, subordinated to the intention that's made clear in Section 9.4. Obviously, I'll come back to that in a moment, but it's that question of subordination which is the matter that divides us. The putative mischief that the appellant has identified, that of the Forestry Act being said to, quote, override planning decisions or said to, quote, preclude development from going forward, that is not a necessary consequence of the statutory scheme. On the contrary, the way that the statutory scheme is structured will mean, and indeed has meant for the last 60 or 70 years or so since the Act, in the vast majority of cases that the Forestry Act in a case like ours will expressly yield to the planning system. This concern about overriding is a quirk, as my lord put it. It is a quirk on the facts of this particular case. It's a quirk of the applicant's own making. It arises on the facts of this case. As my lord, Lord Justice Lindblom put it, if the regimes are operating in sync, as you've said, planning comes first, felling comes later. And that's why this is, so far as we can tell, the first case of this sort to trouble the courts. And these regimes have been operating perfectly happily together for so many years. The supposed catch-22 is not a result of the statutory scheme. It's a result of particular commercial decisions that this applicant chose to take for reasons of its own, not which I'll develop in a few minutes. We have here two separate, albeit sometimes related, regulatory regimes, and that's why, again, with respect, my lord's analogy of the Venn diagram is, I suspect, a very useful way of thinking about it. We have the Town and Country Planning Act, and we have the Forestry Act. The real question for the court is whether a consent granted under one of them can have the effect in law, to use some of the ways the appellant has put it, of superseding, of making redundant, or of subordinating, as Mr. Elvin put it most commonly this morning, subordinating the requirements of the other. And we see also from the appellant skeleton at 61, the challenge is said to be to the Forestry Commission's, quote, refusal to consider the Section 24 notice, quote, superseded. The appellant, as I've said, uses a number of variations on this phrase, the idea of subordination, superseding. And with respect, the difficulty it has in identifying precisely what it says is happening here on its own analysis of the legislation, not ours, on the legal status of the Section 24 enforcement notice is a telling point against its case. And I'll develop this in a moment, but under the applicant's submissions, once the supposed superseding has happened or the subordination has happened, what then? Does the Section 24 notice still exist? What exactly is its legal status? And I'll come to that in a moment. But that is the real issue of principle for the court to decide. Is it right, as the applicant suggests, that a consent granted under one regime, that is to say the planning regime, can have the effect of superseding or subordinating a notice that's served under a different regime, which is to say the forestry regime? That's what we say the issues are, my lord, or the key substantive issue between the parties. I turn then, my lords, to the facts, which of course the court now has, but just a few observations about the facts before I get into the Forestry Commission's analysis of the legal framework. On the facts, as you've been shown, the outline planning permission was granted in June of 2016. You have that behind you. There's no need to go to it now, but you have it behind tab 6 of the supplementary bundle. And as has been discussed already this morning, it was an outline planning permission, condition 1, which the court will find on page 48 of the supplementary bundle. It tells us that matters of layout, scale, appearance of the buildings and landscaping were all matters that were held over as reserved matters for approval, which obviously, as the court appreciates, have to be obtained from the local planning authority in writing before any phase of the development is commenced. So far, nothing unusual, nothing at all unusual about that. The peculiarity, or the quirk, as my lord put it, of the facts of this case is that having received this outline planning permission in June of 2016, the applicant's next step was not to apply to discharge those reserved matters. Had either they or the particular operators, the developers on the individual plots or the sites, taken the normal course and applied for reserved matters approval, and of course if they'd succeeded in securing those reserved matters over some or all of the sites, the consequences could then have been to exempt any development from the requirement for a felling licence. And we'd have no complaint, my lords, about the forestry regime precluding or preventing anything. Which is why, perhaps...
Because that would be a 9-4 situation.
Exactly, my lord, yes. Exactly. Which is why, perhaps, so many decades into the coexistence of these regimes, accepting, of course, that the statutes have been amended over time, this seems to be the first case of this sort to trouble the court, because normally, as my lord says, that 9-4 would do what it says on the tin. In any event, on the facts of this case, the applicant took a different course, as Mr. Elford's explained. It did not apply for the reserved matter approvals which could have activated the exemption under Section 9(4) of the Forestry Act. It could have, it didn't.
I'm sorry, if this is merely pedantic, please tell me so.
Not at all.
You've emphasised the word could in these submissions. Do you mean to submit would?
I mean to submit could simply because we don't know what those reserved matters approvals would have comprised. Had those reserved matters, the schemes that would have been approved, submitted for approval and then approved,
yes.
Had they then immediately required the felling of trees, then they would, my lord.
Yes,
and they would have required. So I just simply say could because we
That's
just
what
we
I
don't
thought
know.
you meant.
Indeed.
Yes.
Now,
Sorry.
not at all. The applicant in this stage took a different course, as of course it was perfectly entitled to. It took a different course. It applied to the Forestry Commission and was successful in applying for a felling licence, as we've seen. Now, the reason for taking things in this different sequence is to do with, so we're told, and it's been explained again this morning, the commercial preferences of the appellant. It wanted to offer cleared sites or oven-ready sites to potential users, blank slates, as it were, to form the basis of subsequent reserved matters applications by those users, by those developers. Perfectly entitled to adopt that course. But it is a course that has different legal consequences to the normal reserved matters approval route. And in effect, again, with respect to the applicant, the real nub of this appeal is what is now an attempt to argue around the consequences which flow from the applicant's own application to the Forestry Commission for a felling licence. That application was made in early 2018. The reason for making that application, we know, and it's in the papers, is because of the appellant's consistent understanding that was confirmed by Mr. Elvin this morning that the outline permission it had received was not enough on its own to authorise the felling of trees. That now is a point of common ground between the parties, and is consistent, of course, with the Forestry Commission's guidance on the topic. So, in early 2018, the appellant applies to the Forestry Commission for a felling licence, and you have that application at tab 7 of the supplementary bundle. Do note, on the facts of this case, it was the applicant, not the Forestry Commission, who proposed what became the notice's restocking requirements. You have that, you need not turn it now, but those requirements are on the application form and in plan form, so they're on the application page 84 of the supplementary bundle, and they're in plan form at page 89. Those suggested requirements, my lords, didn't come from us. They came from them. Now, the applicant relies on its own notes of a meeting in June of 2018, and my lords had a question or two about that note this morning, the minute of a meeting with the Forestry Commission in June of 2018. Just for completeness, those notes were never shared with the Forestry Commission. They certainly were not agreed either then or since then as an accurate minute of the meeting. However, the Forestry Commission, obviously I did ask, has no internal minute of that meeting themselves, and so I'm not in a position to make a submission on what happened, right or wrong. The real point is, of course, whatever the content of those notes is, and indeed really whatever was said at those meetings has no bearing on the question of law that the court has to decide, whichever side is right about it. But it is important to note the
This isn't
significance. Oh, I'm sorry, my lord.
This isn't an estoppel case.
No.
Nobody is saying, well, whatever the law is,
Exactly, my lord.
X or Y or Z. So,
No estoppel, and
so
no-
I think
Yes.
I think it has no bearing on the law.
Nor legitimate
That
expectation.
sounds right.
That's right, my lord. Nor is there any claimed legitimate expectation, as there could have been a link to the idea of an
No,
estoppel.
A legitimate expectation has no place in planning.
No.
See
Reprotect. No, indeed, my lord. And but quite important.
Being corrected, I think.
My lord, legitimate expectations can.
No, I'm
but not
sorry, I meant to
estoppel.
say estoppel.
Yes.
I'm very sorry.
No, of course. Yes.
Estoppel has no place in planning. Lord Hoffman, reprotect, Pepsham.
But there's neither an estoppel nor a legitimate expectation, which is estoppel's.
We haven't pleaded one.
No, indeed. No, estoppel's planning law, public law, cousin. Neither of those rear their heads on the facts of this case. An important point, though, because, my lords, reflect on the significance that this supposed minute of what was said at this meeting has on the submissions of Mr. Eldon, because it really forms the basis of everything that comes next on the applicant's case. They apparently acted on the basis of what was supposedly said, to take a series of steps, including felling trees in reliance on a licence that they had applied for and received from the Forestry Commission. The licence itself, my lords, granted in October of 2018. The covering letter, which again, no need to turn it up, but it's page 90, tab 8 in the supplementary bundle, makes absolutely clear, not that it needed to, but the restocking conditions have to be met. It's only a covering letter, of course, but the licence itself, which you have at page 93, sets out those conditions, and you have them in plan form at page 98. And as I say, on the facts of this case, that those conditions were not that we imposed them, the Forestry Commission imposed them as part of the licence, but they were not of our own devising, they were part of the application from the applicant that we stamped off and approved. Now, that was in October 2018. No challenge to the conditions at that stage, as there could have been. No request that those conditions be reviewed, as there could have been. See section 16 of the Forestry Act that allows for either refusals of licences or indeed for the imposition of conditions within licences to be reviewed and considered. Nothing. Far from any challenge to the licence, or indeed any request to review it or whatever, the appellant did the opposite. It decided very quickly to avail itself of the benefits of the licence. From November of that year, 18, through to February of 19, it felled trees reliant on the licence. So my lords, if you like, it took the benefit of the licence from its point of view, the tree felling bit. But the licence had at least two legal effects, my lords. It not only conferred benefits, it also imposed obligations. And what the appellant did not do is to comply with them. Comply with the obligations imposed by the licence conditions, which takes us forward to July of 2020, when the Forestry Commission served the enforcement notice that the court's already seen. It's tab 14, just for your notes, of the supplementary bundle, page 188. And it required that the restocking conditions be followed, of course. Now, again, albeit that the Act, as you've seen, provides a statutory route to appeal that notice, of course, it wasn't appealed. The notice was not appealed. But not only that, as my Lord Justice Lindblom pointed out, it's not only was there no appeal, there was no response for some 6 months, until January of 2021, around 6 months later, when part of the response included a promise to, quote, ignore the restocking requirements. See Mr. Williams's letter in March of 21, page 221 of the bundle, tab 20. Note.
Just
Oh, my
pause
lord.
there a minute.
Yes, of course.
Supplementary bundle.
Oh, I'm sorry, my lord. Yeah, it's tab 20.
That sounds like 2.
221, is it?
Page 221.
So
I will just, if I just turn it up one moment.
My very clear statement of intent to ignore the restocking and maintenance.
That sounds like the right reference, my lord, yes. Yes, so exactly, my lord, yes. So the letter starts the page before, on page 220. And yes, exactly, my lord, that's the reference. Page 221, given my very clear statement of intent to ignore the restocking and maintenance requirements, ... you may wish to seek an injunction or court order against us. Now, the applicant, as you've heard, disclaims any challenge to the legality of the Section 24 notice. That is, we are told, not the focus of the challenge before the court. I'll return to the reality of that submission later on when I consider delay. It's a point that obviously didn't persuade either of the judges below, but it's the submission that you'll need to resolve. But in any event, my lords, it's a noteworthy feature of the facts of this case that the Forestry Commission has taken 2 formal regulatory steps in relation to this applicant on this site, and only 2. It issued a felling licence under Section 10 of the 1967 Act, and then it issued an enforcement notice under Section 24 of the 1967 Act, and my lords were told neither one of those steps is being challenged, neither was appealed, neither was subject to any review under the proper statutory procedures, including Section 16 of the Act. So it's not them. The challenges instead were told, this is at paragraph 61 of the appellant's skeleton, but we've heard it this morning, it's not to what we have done, it's to the Forestry Commission's failure to, quote, consider the notice superseded. That's the target. So, with those brief observations on the facts, I turn away, my lords, to consider whether or not the legal framework supports the submission that the Section 24 notice has indeed been, as the applicant says, superseded. So I turn away from the facts, my lord, to consider the law.
right, so this is the third part.
Exactly, my lord. Point 3, the law. There are 5 sub-points. I'll tell you what they are, and then I'll address them in a little bit more detail.
If you could go at a speed that enables,
of course,
me at least to write them down.
Yes, my lord, I will. And if I'm going too quickly, please do slow me down. But the first of the 5 is the trump card point. I'm adopting Mr. Elvin's phrase from earlier on. A planning permission is not a trump card. You might also say a carte blanche. They might amount to the same thing. The Town and Country Planning Act is one of many regulatory regimes which govern activities on land. The Forestry Act is another. There are several more. These regimes are separate. Sometimes one is relevant to another. No one regime is systemically subordinate to the other. No one regime has primacy over the other unless and to the extent that Parliament provides.
None systemically subordinate.
Exactly. And no one regime has primacy over the other unless and to the extent that Parliament provides, for example, through the relevant statutory provisions. That's the point about the trump card, which may actually be the most important, that might be the nub, really, of the substantive issue for the court to decide. That's the first of my 5. The second is that the relationship between the Forestry Act and the Town and Country Planning Act, I'll call it the TCPA, maybe, to save some time, is set out expressly and without ambiguity in the relevant statutory provisions. See in particular Section 9, subsection 4 of the Forestry Act.
Expressly and unambiguously.
Yes, my lord.
In the Forestry Act.
Yes, my lord. That's the second point. The third...
Sorry, set out expression in the relevant statutory provisions.
In particular
section
9.4. Exactly, my lord, yes. Yeah. In particular, section 9.4.
Yeah.
The third of my 5 points is actually going to be a very brief one because it's common ground now. the exemption described in section 9.4 cannot be triggered in respect of outline planning permissions without more. I'm not going to say much, if anything, about that now, because as the court's heard, that's a matter of common ground. That's the third. The fourth is a point about retrospectivity. The statutory provisions before the court do not allow a planning permission to have the retrospective effect contended for by the applicant, which is to say that of superseding or making redundant or retrospectively subordinating, if that's not too horrendous a phrase, a felling licence or an enforcement notice issued which had already been issued pursuant to the felling licence.
Did you say overriding? Well, you said subordinate.
I did. I said superseding, making redundant, or subordinating. I'm taking those phrases from the skeleton argument of the applicant. So that's the point about the contended, if you like, retrospective effect that a planning permission is said to have in this case. That's point 4. And then finally, point about withdrawal. Where notices or directions under the Forestry Act can be withdrawn, the Act tells us. And there's no need to imply a power to withdraw a Section 24 notice. Obviously, expand on that in a few minutes. So, my lords, taking those in turn, the first point is the point about the trump card. A planning permission is not some sort of trump card or a carte blanche. Those who would seek to bring forward development on land in England may have to engage with a wide range of different regulatory regimes. And just a few examples will make this point, and I'm not going to labour it, but just to get to so that the court understands what I have in mind, there's obviously the planning system under the Town and Country Planning Act. There may be the need for one or more compulsory purchase orders under perhaps the Acquisition of Land Act. There may be the need for highways orders under the Highways Act. You may need a licence from Natural England in relation to protected species like bats, for example. You may need listed building consent under the Listed Buildings Act. You may need approval under building regulations. You may need a felling licence under the Forestry Act 1967. There are obviously others. But the point is, my lords, that a single scheme promoted by a single developer on a single site in England may trigger the need for compliance with or consent in respect of a range of different regulatory regimes. Now, each regime has a different purpose, of course. And on my Lord Justice Lindblom's image of the Venn diagram, sometimes, but not always, those purposes will interrelate, and sometimes they will touch, sometimes they will overlap. For example, to take the planning regime, the government tells us through its national policy, this is where it tells us this, that the purpose of the planning system is to contribute to the achievement of sustainable development. We get that purpose at paragraph 7 of the MPPF, and for your reference, it's Authorities tab 7, page 192 of the bundle.
Yes.
And if we want to derive or to consider what the purposes are of the Forestry Act by way of compare and contrast, one need turn only to the Act itself, which is in the Authorities bundle at tab 1, if the court could just turn there very briefly. It's section 1 of the Act, which establishes the Forestry Commission on tab 1, section 1. It's internal. It's bundle page 3, and we see, my lords, that the subsection 1 establishes the Forestry Commission and refers to the commissioners, and it's at subsection 2 that we start to understand what the duties and powers of these commissioners are going to be. So subsection 2 tells us what the general duty is of the Forestry Commission. It's to promote the interests of forestry, the development of afforestation, and the production and supply of timber and other forest products. So that's our starting point. But there's a bit more, my lords, if you turn over the page to page 4 of the authorities bundle. Subsection 3 tells us that that general duty above includes that of promoting the establishment and maintenance in England and Wales of adequate reserves of growing trees. So there's that, if you like, general duty. That's part of the general duty that Parliament has identified above. And then we get, my lords, 3A, which goes a little further. It tells us that in discharging their functions under the Forestry Acts 1967 to 1979, the authority shall, so far as may be consistent with the proper discharge of those functions, endeavour to achieve a reasonable balance between two things. First is the development of afforestation and the management of forests, that's the first. And the other thing is the conservation and enhancement of natural beauty and conservation of flora, fauna, geological, physiographical features of special interest.
Those words were added by the Wildlife and Countryside Amendment Act 1985,
Yes,
Section 4.
Exactly so, yes. Now, we can derive from that the general purposes of the Forestry Commission and the Commissioners and the duties with which they have been charged through Section 1 of the 1967 Act may sometimes overlap with, but are obviously different from, those of the planning system. Different regimes with different purposes. There's no legal basis to subordinate one set of objectives, say the promotion of or establishment and maintenance of reserves of growing trees, whichever one it may be, to another, the achievement of sustainable development, say. No legal basis to subordinate one set of objectives to the other. These regimes coexist. They operate in parallel, along with, I mean, we're focusing on only these two, but of course there's a range of other regimes with their own purposes, to which I've already referred. And unless Parliament has told us that one of these regimes must yield to another, there is, we say, with respect, no basis at all for the court to infer or to derive a relationship of subordination or of systemic primacy one over the other. And just to make a point on the facts of this case, my learned friend's point is that felling considerations, if you like, are, his words, subsumed into wider planning considerations, such that, if you like, there's nothing left to be done, nothing else to think about, and once the planning permission's been granted. But consider the chronology in this case. Your Lordships have the dates. October 18, felling licence granted. November 18 to February 19, the felling occurs pursuant to that licence. We have the enforcement notice in July of 2020. September 2020 is the grant of the planning permission, the full planning permission for the access road. By that time, to state the obvious, but it perhaps warrants stating, the trees had gone, the felling had happened. There was no objection from the local authority's tree officer to the access application because there were no trees left to consider by then. And we can see that, not from a document that's before you, but if you'd like it to be put before you, I can put it back in, we've got printouts of it. It's the officer's report to the council, the local planning authority, in respect of the access application. There's no objection from the tree officer. And the reason why is that the majority of the site, quote, has now been clear felled. It's not in the papers, no. And if the court would like to see it, we can obviously we can hand it up.
What is this document?
It's the case officer's report.
Case officer's report.
In respect of the 20. Let me get the right dates.
If my London friend's going to rely on it, I think it ought to go in. But
very happy.
It's the first time he's mentioned it.
Very happy. You know, I noticed that it wasn't in the bundle, which is a shame. But I'm very happy for it to be put in.
Right. Well, I think that to avoid any misunderstandings or difficulties, let's have the document.
I'll ask for it to be handed around. Sorry, I didn't know what we were going to do. My lords,
Just pause for a
of course, of course, of course.
Thank you. Right. Now,
This
you want
is,
to identify the part.
of course, my lord. Yeah, this is the delegated report, as you see from the first page, from the local planning authority recommending conditional approval in respect of the access road from Trago Mills, including a footway. So that's what this is. It's the reasoning that sits behind.
This was for a meeting on the what date?
The date of the document is the 11th of September.
Oh, great.
That's on the last page.
And the granted permission was on the 14th of September.
So this was a committee meeting on the 11th, was it? Of September. For which committee was this?
Yeah. I wonder whether, my lord, it was a delegated approval.
Okay.
Delegated report at the top of page 1, so no committee involved.
All right, so it's a delegated report.
Delegated report, date 11th September, and it led to the issuing of the 14th of September planning permission that the court has at page 107 of the supplementary bundle.
All right.
Now, the only purpose for showing your lordships this report is to understand it. Your lordships turn into page 8.
Yeah.
There's a box headed consultee responses, and we see the comments of the tree officer, which are dated March of 2020, and the responses. There's no arboricultural objections to the proposal, as the majority of the site has now been clear felled. There's no dispute between the parties about this chronology, and you might think, well, that comment of the tree officer is totally unsurprising. Nothing else to consider, if you like, from the tree officer's perspective, because the trees have been felled. But the reason for showing my lordships this point is because it does rather belie Mr. Elvin's suggestion that the planning regime subsumes all of the considerations that the Forestry Act would have thought about, because by the time this planning permission is being determined, well after the grant of the licence, well after the trees have been felled, there's no trees for the planning regime to think about. And for completeness, my lords, the Forestry Commission is not consulted as a matter of course about these planning applications, and wasn't consulted in respect of this planning application. So that's why there's no, on the list of consultee responses, you've got the local authority's tree officer giving his or her view. You don't have the Forestry Commission saying, oh, well, you know, by the way, this would be inconsistent with an ex-ante enforcement notice. In any event, that's the first of my 5 points on the law, which is the point about the trump card, the idea that one regime, if you like, is capable of subsuming another. We say that it simply doesn't. There's no legal basis for the court inferring that sort of subordinate relationship, one over the other. The second of my 5 points, my lord, is about the relationship between the Forestry Act on the one hand and the Planning Act on the other. Because happily, unlike some cases, this is a case where Parliament has applied itself expressly to the question of how these two regulatory regimes should interrelate. We have the answer. We have it expressly, and we have it without any relevant ambiguity. The regimes are linked, and they're linked for our purposes in Section 9 of the 1967 Act, which your lordships have seen several times already, but just to turn it up one more time. So it's again tab 1, internal page 14, sorry, bundle page 14.
Yeah.
Now, Section 9 of the 1967 Act, the central function of that section, and the title of the section rather gives it away, but it's perfectly clear, the central function of this section is to impose a licensing requirement for felling. See Section 9.1. That's what this section is doing. But then, of course, having imposed, if you like, that general requirement for a felling licence, the subsequent subsections that follow set out a number of exemptions to that overarching requirement for a felling licence. That's what's happening here. And the of course, the one which is of particular interest to the courts on page 15 over the page, subsection 4D. Now, it's an odd feature of this case that for all of the attention that my learned friend lavishes on this subsection, it's not a provision that actually arises on the facts of this case at all, because, of course, the felling, which occurred in late 2018 and early 2019, occurred, my lords, not under any exemption, but pursuant to the terms of a felling licence that had been applied for and had been granted in October of 2018.
I think Mr. Elvin
He's accepted
that in the question that I put
Yes.
to him earlier, because he accepted he couldn't rely on section 9.4D
Yes, my lord.
directly.
Quite right.
It's the indirect relevance that he says it has.
Quite right, my lord. Yes, that was my understanding of his submission this morning too. And as I understand it, the applicant relies on section 9.4D as a pointer, if you like, as evidence of a more general parliamentary intention that, if you like, the planning regime subsumes or should be preeminent over, should subordinate the forestry regime. So I make the following very short submissions on what this section does and doesn't do. First, at most, all it can possibly do is to disapply the overriding licence requirement in section 9.1. No more, no less. That's it. So it controls one of many possible exemptions from the general requirement for felling to be licensed. It does no less than that, so it's a very important provision, but it doesn't do any more than that. Second, my lord, it says nothing about a number of different things. So it says nothing about granting relief from any conditions or obligations imposed by a felling licence that has already been granted. Of course, it's not concerned with that scenario. It says nothing about exemptions from restocking requirements after trees have been felled pursuant to a licence. It says, perhaps this is really the point, nothing about retrospectively superseding the requirements of a licence which has been granted if, at some point in the future, an immediate requirement were to arise to fell trees pursuant to a planning permission.
Nothing to say retrospectively. What was the verb?
It says, my lord, nothing about retrospectively superseding, this is again to use the applicant's lingo, the requirements of a licence, superseding the requirements of a licence which has been granted, if at some point in the future an immediate requirement were to arise, future tense, to fell trees pursuant to a planning consent. The short point, my lords, is that section 9.4D does not say any of the things that the applicant needs it to say. So we have here two separate regulatory regimes which Parliament has linked in a particular way through section 9.4D. The meaning of that provision is unambiguous. There is no longer any dispute before the court as to what the meaning of this provision is. It's an important but specific exemption mechanism to the general licensing requirement. Now, its application 9.4D to the facts of any case will require the exercise of evaluative judgment. That's really the answer to my lord's question from earlier on about why did I say a subsequent reserved matter approval could, rather than necessarily would, be exempt, because it would depend on an evaluative judgment, looking at the relevant reserved matters approval and asking oneself, is it therefore immediately required pursuant to this consent?
Well, sorry, again, I don't want to be pedantic. You say evaluative judgment. Is it really fact and evaluative judgment?
Yes, it is. It is fact and evaluative judgment, my lord. I simply say it's not only a question of fact. That there there is an element of evaluative judgment that goes into the exercise.
Yeah, so it's both fact and evaluative.
Yes, my lord. I'd absolutely accept that. But the final point is that there is no basis for reading into this, one might have thought relatively modest, subsection, a general parliamentary desire for the planning system to supersede or subordinate the forestry regime as a whole, or at least so far as development is concerned. That is not at all what it does. And there is, again, with respect to the applicant, no basis for extending its meaning so very, very far from the express, unambiguous and targeted language of the statute. Now, that was the second of my 5 points about the law. The third is the one that I won't develop at all anymore because it's now common ground that the exemption that we see at 9.4d cannot be triggered in respect of outline planning permissions on their own. My lords have got the position on that.
So your third point is common ground.
Yes. The fourth point was this point about retrospectivity. My lords, the statutory provisions do not allow a planning permission to have the retrospective effect contended for by the applicant. But when I say that, retrospective effect, what I mean is the effect of superseding or making redundant a felling licence or an enforcement notice issued pursuant to a felling licence that's already been made. Again, at paragraph 70 of the applicant's skeleton argument, we get the language of subordination. The felling licence, it said, and the enforcement notice served pursuant to that licence should be subordinated. And Mr. Elvin developed that submission this morning. To what is it said that they should be subordinated, my lords? To, we're told at paragraph 70, the supposed intention, quote unquote, of Parliament. That's the applicant's starting point. The applicant's case, as I've already submitted, seeks to derive Parliament's intention. That's its necessary step one. And it does that, we say, entirely, well, we say, the Forestry Commission says, by overreading what is a narrow exemption at section 9.4d of the 1967 Act. No other evidence put before you to support a more general parliamentary intention one way or the other, but alas, that's its case. And step two for the applicant is, having derived that intention, the applicant then seeks to make express statutory language in the 1967 Act subordinate to it, i.e. subordinate to the supposed intention that it has derived from section 9.4d. That's the logic of Mr. Elvin's case. What is the nature of the supposed intention that is derived by the applicant? It is said to be, again, at all paragraph 70, it's said to be an intention that, quote, felling regulation does not apply where planning permission immediately requires felling. Felling regulation does not apply, which is, on our submission, a bold intention to derive from so modest a piece of statutory language as 9.4d. But the real point, my lords, is that the terms of the 1967 Act are very simple, I hesitate to say after arguing about them all morning, but they are. They do not support the applicant's inferred intention. We know, under section 9, that there'll be no need to apply for a licence to fell if the conditions of a relevant exemption are met. A number of relevant exemptions that are possible. Now, section 9 does not tell us that once a licence has been applied for, granted and acted upon, that felling regulation, quote, does not apply if later on, some point down the line, a planning permission were granted. It's a submission I've made before. If that's what Parliament had meant, it's had decades to amend the Forestry Act to achieve precisely that outcome, and of course it's not done that. It's a very simple scheme, my lords. You apply for a licence unless you're exempt, section 9. The Forestry Commission will impose restocking, or can impose restocking conditions If the Forestry Commission decides that it's expedient, quote unquote, to do that, we get that at section 12. Now, if you, the applicant, object to any of those conditions, you can ask for a review, section 16. But if you stay silent, if you fell trees in pursuance of the licence, you are bound then by the conditions which pertain to the licence. If you fail to comply with those conditions, then the Forestry Commission can, not must, but can, issue an enforcement notice under section 24(2). Now, if you receive an enforcement notice under section 24, my lords, you have three options. You can lodge an appeal under section 25. You can comply with the notice, or you can do what this applicant has done, which is to ignore the notice and risk criminal prosecution. Those are your options. But there's no fourth option, my lords, of applying, if you like, to sort of retrospectively vary or render redundant that notice by applying for planning permission. There's no mechanism in the Act to get around the enforcement notice by applying for planning permission, because even if you do that, as the applicant has done, and even if you receive a planning consent, which of course the applicant has also done, that new planning permission has no legal consequence on the validity of or the need to comply with the matters that have already been set out and enforced against in your section 24 notice. That notice existed before the planning permission. It continues to bite, notwithstanding the planning permission. These are two regulatory regimes which are different and they serve different purposes. And as I've said already, one does not have systemic primacy over the other.
So on your retrospectivity point, just trying to think that through.
Yes.
You say the effect of the appellant's argument is that what would otherwise be a valid felling licence and therefore a valid enforcement notice, and neither are said to be anything other than valid, the effect of the argument is that there is a power at some point down the line to effectively wipe out their effect. You make the separate point, well, they've already felled the trees in accordance with it, so that might be difficult. But you're wiping out its effect, and what you say that's potentially quite an unusual provision.
Yes.
And that the very least that one would expect is something set out in a statute somewhere, yes. Because this isn't, as it were, a straightforward few missing words. Is this right? Have I got the submission
you do,
right?
my lord, yes.
That effectively you're saying this would be a very unusual thing and would therefore need to be expressly and carefully spelled out.
Yes. Exactly. The submission that's made by the applicant, my lord, is, as I say, I've referred a few times to paragraph 70. It's in several places in the applicant's skeleton argument, but the court might think that paragraph 70 is quite a neat encapsulation of the way that it's put. The final sentence of that paragraph, which talks about subordination, etc., the final sentence tells us that it's claim, the core bundle, page 42, paragraph 70 of the skeleton. Where it becomes clear, it's said by the applicant that development will proceed following RMA, following Reserve Matters Approval, and that the permission requires trees to be felled in order to be implemented. Then it is submitted, the applicant's case is that the section 24 notice should, quote, cease to have effect. That's the way it's put. Since the obligation to seek a licence at that point ceases. But, again, with respect, that submission conflates different things. A section 24 notice is not about whether there's an obligation to seek a licence in the first place. That ship has sailed. It's about something different. It's about observing the requirements of a licence which have already been granted. The key submission, my lord, that the applicant deploys to support what we say is a conflation, is not about statutory construction. It's more about what is said to be a mischief that's created by the Forestry Commission's position. See, for example, it comes out in many places, but at paragraph 74 of the skeleton, it said that the Forestry Commission's approach to section 9.4 sterilises its ability to implement development for 10 years. But again, my lords, that is not a problem which is inherent in the statutory scheme. In the normal run of events, when, as my Lord Justice Lindblom said, as you put it, when the regimes are running, if you like, in sync, or in the way that they normally would, when reserved matters approvals follow an outline planning permission, this situation doesn't arise. It's an issue, a quirk, of the applicant's own devising. It arises on the particular facts of this case. And that is because of its desire to clear the site without the benefit of reserved matters approval for whatever reason. And that led the applicant, as we have seen, the applicant itself to suggest restocking conditions in its own licence application, which in effect it's now decided that it does not want to adhere to. An unusual fact, not come before the courts before, so far as we're aware, but those unusual facts do not support straining the statutory language well beyond the meaning that it can bear. Lords, I think there's time before lunch to deal with the power of withdrawal. It may be that we go a couple of minutes beyond 1 o'clock if the court's content.
Yes, that's fine.
Thank you. So the fifth of my 5 points about the law, and that leaves only delay to deal with after that, which won't take long, perhaps after lunch, but I'm in the court's hands.
Yes, well, we'll take your submission on point 5.
Yes.
And then we'll
Perhaps
stop.
see where we. Yes, my lord. Okay. The fifth of the points of the law is about the power of withdrawal. Now, to start at the beginning, the parties agree there's no express power in the 1967 Act, which allows the Forestry Commission to withdraw a Section 24 notice. Now, that lack of an express power matters in this case because this is an Act, unlike, I should say, the EPA 1990, which is the subject of the Everett case, to which we'll come. This is an Act which does expressly deal with powers to withdraw other things, not Section 24 notices, but other things. And to give the court just two examples, if the court could turn in the Act, let's tab 1 of the authorities, if the court could turn to bundle page 24 in the authorities bundle, the court will find Section 17A inserted into the Act in 1986. Section 17A, bundle page 24, is dealing with a power to issue something called a restocking notice, as you'll see from subsection 1. There's a power to issue something called a restocking notice if it appears that there has been unauthorised felling. We need not get drawn into the detail of what that means, but you'll see over the page at 17B, page 25 of the bundle, there's the possibility under 17B of an appeal against a restocking notice. A person on whom a restocking notice has been served who objects to the notice or any condition can refer the matter to or the minister would then refer the matter to a committee appointed in accordance with Section 27, etc. And then does the court see at subsection 2, the minister then can after considering the committee's report, direct the appropriate forestry authority to withdraw the notice. So it can be withdrawn, or to notify the objector that it shall have effect subject to such modifications as the minister shall direct. So that's one example of the express possibility of withdrawal of something it being put into the Act. But there's another. The court turns over the page to Section 18, bundle page 26. Section 18 deals with something called felling directions. It's a power to issue what's called a felling direction, if it's thought appropriate by the Forestry Commission. And again, my lords, under Section 20 of the Act, which is bundle page 28, in a very similar form, there's the possibility of asking for a review of a felling direction. So it's bundle page 28, section 20. if a person to whom felling directions are given is aggrieved, and on the grounds that the felling is not expedient, he may, by notice served within limits of time, request the minister to refer the matter to a committee, etc., etc. It's the same structure as the previous withdrawal provision. And then again, the court sees at 20 subsection 2, the committee makes a report, and then, as a consequence of all of that, the appropriate forestry authority, end of subsection 2, shall either confirm, withdraw, or modify the directions in accordance with the report. Now, on section 24 itself, my lords, your lordships just turn forward to page 32 of the bundle. Section 24(1) sets out the two alternative bases, A and B, 1A and 1B, that might, either one of which might lead to the service of an enforcement notice under section 24. We see what they are. That works required to be carried out in accordance with conditions haven't been carried out, or any felling directions given by the appropriate forestry authority aren't complied with. Now, someone who thinks that their notice has been served in error need only read on to section 25, which is on bundle page 33. And they have a statutory right of appeal. On one of two grounds, on A and B, 1A and 1B in section 25. Now, it's said by Mr. Elvin that those are narrow grounds of appeal. With respect, that's not so. They're the only proper grounds on which an appeal could possibly be brought, because 25(1A) and 25(1B) cover the same conditions at 24(1A) and 24(1B) that might justify serving a notice in the first place. So it's essentially saying one or other of the conditions that led you to serve this notice are wrong. You've reached the wrong view. So those are the only grounds upon which an appeal could be brought.
Well, I think up to a point Mr. Elvin accepted that.
Yes.
Because I put to him that when he said about a material change in circumstances, I said, well, that's not an appeal.
Yes, that's right. Yes, yes, my lord. But what are the consequences of such an appeal if one were brought? If my lords turn over to the top of bundle page 34, and it's the subsection 4 right at the top, so it's section 25, subsection 4. The committee to whom such a matter is referred, after complying with section 27.3, makes a report. After considering the report, the minister will either confirm or cancel the notice to which the reference relates. So here, those are the options. There can be confirmation of the notice, or there can be cancellation of the notice pursuant to this appeal process.
Yes, but of course the minister wouldn't be withdrawing it, would he?
No. No, that's right.
I'm not sure how that's not analogous to the provisions you were showing us just now.
No, it's not. It's not analogous. It's different. You're right, my lord. But the point is that here there's an express mechanism. It's not a withdrawal mechanism. It doesn't use the language of withdrawal.
No. But the point I thought you were making, which may perhaps be the primary point here, is that where the legislature has wanted to provide for withdrawal, it has consciously and explicitly done that.
That's the point, my lord. It doesn't go any further than that. That's it. And that takes us to the Everett case, which I can deal with, I hope, briefly in the next couple of minutes.
Right.
My lords have been shown the reasoning of Mr. Justice Richards, as he then was at tab 10, and then the Court of Appeal, and in particular Lord Justice Mummery, which is in tab 11.
Yep.
The first point to make, and it's not the point on which the case turns, but it is worth noting that this point about withdrawal is obiter. And we see that from tab 11, it's, let's see, it's bundle page 239, case report page 1179. As Lord Justice Mummery says, under the heading conclusion on that page, he says the issues relating to the power of the council to withdraw a valid abatement notice which has been served, not successfully appealed, etc., do not need to be decided on this appeal. So a starting point, but an important starting point nonetheless.
Sorry, I missed where you were reading.
Of course, my lord. No, if it's on, so it's report page 1179,
Page, yes.
bundle page 239. It's under H.
H.
There's a subheading conclusion.
Oh, it's there, is it? Yes, I've already
Yes.
highlighted.
So it's not at all. So it's the second sentence in that. Sorry, third sentence.
Oh, yes.
The issues relating.
Sorry, I was looking
Not at
further
all.
up the page.
So that's the first point. This is all obiter in relation to this point about withdrawal. But then just very briefly, nonetheless, dealing with the sort of the merits of the analysis, whether it's obiter or not, going back to what Mr. Justice Richards said, which is at tab 10, starting on report page 105, bundle page 227. It's under, obviously at D, there's issue 3. Was the council entitled to withdraw the abatement notice from page 2, bundle page 227?
And between D and E, he explains why it's obiter.
Yes.
Because my
Yes.
conclusion on the first issue is also effectively determined with the third issue.
That's right.
Again, however, I think it right to consider what the position would be if I were wrong on the first issue.
Yes, my lord. Yes, exactly so.
Yeah.
Yes, quite so.
And then the reasoning is over the page 228 D to F.
That's right. There's a bit more before we get there. H on 105 paragraph H. These are recording the submissions of Mr. Bowes, but you'll see over the page at D he accepts the submissions of Mr. Bowes. So it might just be worth also noting what's said there, because the court, as I understand the reasoning, is recording and then accepting these submissions as well as giving his own reasons. But you'll see right at the bottom of page 105, there's this idea about the principles of finality and certainty require, right at the bottom of the final 2 lines of 105. The principles of finality and certainty require that if the authority decides not to prosecute, it may also formally withdraw the abatement notice itself. So one of the arguments at play was this idea about finality and certainty. But it is a different situation here than it would be under the EPA in respect of those arguments, because section 24(4) requires any criminal proceedings in relation to an enforcement notice in the Forestry Act to be instituted within 2 years. So there is an important difference between the EPA, or the Environmental Protection Act, and the statutory nuisance provisions, and the Forestry Act on this question about, if you like, the applicant being left dangling well into the future, not knowing whether they're going to be prosecuted or not. There's a distinction there. The next important distinction is over the page 228 of the bundle, 106 of the case report. In between A and B, there's a reference to the general duty in the Environmental Protection Act to inspect an area, quote, from time to time. That's a few lines down, which is part of the statutory nuisance regime. The enforcing authorities under an obligation to maintain inspections, quote, from time to time. And as a consequence of those inspections, if they are satisfied and a nuisance exists, then an abatement notice may be issued. That's the structure of the EPA. But there's no continuing obligation in a similar way under the 1967 Act. The Forestry Commission is not obliged to continue to inspect sites from time to time and sort of maintain a sort of up-to-date view, if you like, on whether or not a notice has been, or a licence obligations have been met or not. They're entitled to reach a view and then to enforce on the basis of that view. There's no maintaining obligation in the same way as there is under the EPA, so the positions aren't analogous there. And then, as Mr. Elvin accepted, between D and E, the logic, and this is really where Mr. Justice Richards goes from accepting Mr. Bose's submissions to giving his own reasons, it seems senseless that an authority should be unable, under D, to withdraw an abatement notice, which for whichever reason it no longer considers to be appropriate. Of course, to state the obvious, but an important consideration in Mr. Justice Richards's reasoning doesn't apply here.
But Mr. Summons, you may want to consider this over the adjournment and come back to it. But I think, with respect, you're descending to the facts there rather than the principle.
Yes.
And I'd be grateful for your assistance with the power or non-existence of a power. If in a hypothetical case the Forestry Commission realised to its horror it had made a terrible error, it was now issuing an enforcement, or had issued an enforcement notice in relation to a felling licence which actually it never issued. It thought it had issued it, but it turned out to have been a terrible mistake, very embarrassing all round. I think the effect of your submission is that the only way out of that would be for the person affected by the enforcement notice, no doubt with the assistance and cooperation of the Commission, to go through the route of asking the Minister to take some action.
Yes.
But one can well imagine a situation where Parliament was in recess. It was going to take weeks to get along that route successfully.
Yes.
So perhaps you'd just like to consider whether, as a matter of principle,
Yes.
everyone's stuck with that situation, or whether there must be some sort of residual power.
Yes, my lord. No, and our answer is that, fortunately or not, that we are, if you like, stuck with that position, because the only outcome, as my lord has anticipated, would be one of cancelling such an enforcement notice pursuant to section 25(4) of the Forestry Act. But this is an act, unlike some acts, this is an act which is comprehensively set out what the mechanisms are in different circumstances to enable different things that it creates, directions, orders, enforcement notices, to be varied, confirmed, withdrawn, or as the case may be, cancelled, which would be on my lord's hypothetical, that would be where we'd go. Now, the procedural rights and wrongs of that, if you like, whether or not it would just make a lot more sense to do it quicker and avoid troubling the minister who's off on their summer holidays. That may be that's a more sort of expeditious way of dealing with things. But these are questions for Parliament, and this is an act which has addressed those questions expressly.
Yeah.
Just while we're about to adjourn, it's probably worth mentioning my desire to recall planning enforcement regime. I can go and look it up, of course,
Yes, my lord.
adjournment, but the power to withdraw a planning enforcement notice, is that explicitly provided? It is, yeah. In section 1(7).
We can
About
1.
in the 7(2), yeah.
Oh, is it there? Yeah.
We can find out.
We'll bring the provisions
there's
along.
a little gentle homework for the
Very grateful.
which enables me to say that we'll come back at 2:10.
Thank you.
Very much.